I'm here with Sid Rao, litigation partner at Romano Law. And today we are talking about the differences between libel and slander.
People often use these terms interchangeably. General public might say libel or slander. There are really different types of defamation. They're both involve statements that are false and damaging. The difference is that in libel, it's published in writing, so it's written somewhere. And in slander, it's spoken, right? It's not written down. So, if something is published in a newspaper or a book or even a tweet or a Facebook post, now we're in the libel side of that spectrum. If something is spoken, whether it's at a party or on a phone call or, otherwise just verbally communicated, that would be slander. So that's the other side of it. And that's really the only distinction pretty much between libel and slander. Otherwise, they're very much defamation types of claims. Now, that's again, that's kind of like a textbook distinction, but from a lawyer and a litigator and a litigation perspective, they are very, very different, because when something's in writing, it's easy to from an evidence perspective to say, hey, judge, look at this tweet or this article. They said these words, and it's provable, right? Because it's in writing. Sometimes with defamation that is slander, it's just harder to prove that somebody said something to somebody else, whom they said it to, and those and when and all of that, phone calls and things that aren't recorded can be very difficult to prove up in court. So that's the real difference in the practical sense between libel and slander.